All right. All right. Good afternoon, everyone. Welcome to the Judicial Proceedings Committee. Today is Tuesday, March 26th. We have 20 bills on the docket, and I'll excuse the members up front just because we have a lot of folks across the street, as you are over here. So we're a little light on attendance, but that's just because that's what time of year it is. So we're going to start off with the Speaker's bill. Madam Speaker is here. We're going to start off with House Bill 810. And I know that you have a sponsor panel. Is that right? You'd like to bring up?
Just answer questions.
Can you turn her mic? Thanks. Madam Speaker, the floor is yours.
Oh, yeah, I'm just waiting for them to sit down. So, good afternoon, Chair Smith, Vice Chair Wallstricker, and members of the Senate Judicial Proceedings Committee. For the record, I'm Speaker Adrian Jones. I'm here today to testify in support of House Bill 810, legislation to prohibit the use of a Glock switch or any other auto sear device in Maryland. These small devices, which convert legal semi-automatic firearms into fully automatic machine guns, make our communities more dangerous. In fact, my county, Baltimore County, has seen an alarming rise in cases in which one or more firearms has had a Glock switch. And the mass shooting at Morgan State University last October involved a weapon with a Glock switch. The high volume of these devices in circulation and the fact that they can be produced by a 3D printer in someone's home make it very difficult to control their use. Despite a federal prohibition, law enforcement and prosecutors in Maryland believe this legislation will provide them with an additional tool to get Glock switches and similar devices off our streets. At the end of the day, automatic weapons have no place in our community. House Bill 810 is a critically important bill to help keep our neighborhoods safe, and we look forward to working with this committee to make sure we get the bill right. Thank you, and I respectfully request a favorable report on House Bill 810. Speaker next. Thank you.
Thank you very much, Madam Speaker. We'll hear from the panelists first, then we'll take questions from the committee. So whoever would like to step up to the podium.
Good afternoon, Mr. Chair and members. I'm Chief Robert McCullough of Baltimore County Police Department. I encourage the committee to support this bill as passed by the House. We are finding alarming numbers of these devices in Baltimore County, both at crime scenes and while executing search warrants. I'll briefly address the details of the bill, which are described more fully in my written testimony. These devices are already illegal under federal law. The definition provided for switch auto sear accurately describes and defines the device and is consistent with the definition in the Federal Criminal Code. The bill, as passed by the House, adds the switch auto sear into Maryland's criminal code in the same way that rapid fire trigger activators like bump stocks are already prohibited. By removing the word trigger and more generally prohibiting the rapid fire activators, the amended bill effectively prohibits fully automatic weapons in Maryland, no matter what devices may be invented in the future. The penalties for using a switch auto sear in the commission of a felony or crime of violence will be the same as existing penalties for using an assault weapon or bump stock or similar device or high capacity magazine. This important legislation will give us the ability to bring state criminal charges for having, making, or trafficking these devices, even if they are not attached to a firearm when we find them. I'll be pleased to answer the committee's questions about what we are experiencing in Baltimore County, and I urge a favorable report.
Good afternoon, Mr. Chairman, Mr. Vice Chairman. My name is Meg Ferguson. I'm Senior Policy Advisor to the Chief of Police of the Baltimore County Police Department and Director of the Legal Section. And I'm just here to answer any questions that I may be able to assist with and really to say me too to the speakers. Bill, thank you, sir.
Chair, members of the committee, Scott Schellenberger, State's Attorney for Baltimore County. I did supply written testimony. I hope that will suffice, but very quickly, what House Bill 810 does is takes a much needed, makes a much needed law to make it unlawful for a very dangerous device that can turn a regular gun into literally a machine gun. This state, and particularly this committee, has a long established history of outlawing machine guns, assault long guns, and assault pistols. This body even stayed very current a couple years ago when a new device was invented called a bump stock, and this is just merely an extension of that. The committee keeps up with the new and dangerous weapons that are out there and makes them illegal. The device in question is very cheap, is relatively easy to install. It can even be made with a 3D printer, or you can buy it for as little as $30. Some people on the other side of the house asked us about the fact that it's illegal by the feds. We have not seen the feds wanting to take these cases from us here in Baltimore County. And as my chief indicated, we do get quite a few of these. So with that, I respectfully ask that you pass House Bill 810. And actually, one of the things 810 does, and the reason why they made changes and amendments to it, was because we're trying to encompass something that might be invented in the future. And that's why the word trigger was taken out, was because we're trying to anticipate what the next genius person is going to do to make something dangerous.
Excellent. Thank you very much. Questions from the committee? Said a couple, go ahead. Good. Vice Chair Walser, you good?
Thank you, Mr. Chairman, and thank you, Madam Speaker, for bringing this really important bill. My questions are for you, Mr. Schellenberger. So most of these trigger switches are being done to Glock models. Is that true?
Yes.
And do you know, now that Glock has noticed that that there's a problem with their guns that are being illegally modified, has Glock changed their design or taken any steps to mitigate?
Not to my knowledge.
You prosecute a lot of cases related to auto theft about Kias and Hyundais. Is that right?
Correct.
And that's because there was some kind of design flaw where people can easily break into those vehicles.
Correct. You can actually go on YouTube and watch a video and learn how to do it.
And to your knowledge, have Kia and Hyundai taken steps to remedy that issue in their design of those vehicles so that that's no longer the case with the Kia and the Hyundai vehicles?
It is my understanding that they have redesigned the ignition system so that they, in fact, prevent that particular way of starting the car or overdoing the car to happen.
And part of the reason they redesigned that is because they were sued by a number of plaintiffs as well as attorneys general for that issue. Is that accurate?
Yes.
And isn't it true that Illinois, and I believe the city of Chicago, has similarly sued Glock for their failure to alter the design of the weapon so that it can no longer be modified?
So I'll put my prior hat on where I used to work as a plaintiff's lawyer. Yes, they have. There have been a number of suits against Glock for this. And so you are correct that that is something that can happen.
But to your knowledge, even now that those suits have begun, there's been still no change to Glock's production of these that would allow them to be illegally modified by a third party.
It is my understanding that they have made no changes at to this point.
Thank you, Mr. State's Attorney.
You may note that there's a certain bill floating around for industry liability that may be referenced in.
I know. why I was up there.
Yeah, yeah. No, question is, so look, I think the federal law, and this is for either the chief or for Mr. Schellenberger. So machine guns outlawed around 86. I think the state adopted our regulation after following the federal government. So the question is, does this apply? Is this prospective only? Or does this apply retroactive? That's one question. Second is, does this also apply to law enforcement? Are law enforcement officers able to have?
Well, first of all, law enforcement officers aren't allowed to possess these items or to possess automatic firearms either. Our firearms are semi-auto. And in terms of this, being, illegal, it's illegal under federal law.
So that's correct. But what we're seeing is our friends at the U.S. Attorney's Office, there's so many of these cases, and frankly, they can be viewed sometimes, unless it's being used as low-hanging fruit, that they are not interested in taking just the mere possession cases. And that's what we need this ability to take it when we say go in for a search warrant for drugs and we find a Glock with one of the switches on there. We want to make it so mere possession can be prosecuted.
Okay. All right. Thank you all very much. Appreciate it. All right. That'll conclude the testimony for the proponents of the bill. Now switch to the opposition panel. I believe is it Mark Penick?
Thank you, Mr. Chairman. I'm not here, I'm Mark Panic, I'm president of Maryland Show Issue. I'm not here in opposition or in support of Glock switches. Glock switches are illegal under federal law, and that's as it should be. I'm here to tell you, however, that existing Maryland law already bans the possession of a Glock switch because it is a device that increases the rate of fire. If you look in 5-301M, subpart 1, this is in the bill itself, you will see that the Glock, a rapid fire trigger activator is in fact defined in part as any device that increases the rate of fire. There is absolutely no doubt whatsoever that a Glock switch does that. So existing state law already does exactly what this bill does. It is superfluous. And I have no idea why it's not being enforced in Baltimore. My understanding is that this existing state law is already being used to prosecute possessions of Glock switches in Montgomery County. So maybe Baltimore can talk to Montgomery County and figure out how they're doing it, because that's pretty obvious. Now, there are other points, the definitions and other matters there. This legislation is certainly better than the original bill, but as defined, it creates a lot of ambiguity. It might sweep in legitimate collectors who hold World War II relics and the like. Those people are not the problem, and they ought not to be swept in with this legislation that's ill-defined terms and a lack of definitions on these terms, like a trigger bar. No one really knows what a trigger bar is. Not defined on this is if you establish some antique firearms use a trigger bar because they're part of the trigger, but there's no definition of this. If you have an existing legislation that already covers it, there's no need for this. Be happy to take questions.
Sure. Thank you very much, Mr. Penick. Look, I don't think anyone should have machine guns, period. That's just me. But so under the federal law, though, if you had, I'm not talking about curios or relics. I'm talking about anything before 1986 or whenever the federal law went into place and then Maryland adopted. Could you possess, if you registered with Maryland State Police, a machine gun before in 1986?
Yes, if it was manufactured before May of 1986, and if you jump through all the hoops with the ATF, which includes fingerprinting and background check before any acquisition. And you pay the fee, the tax, and you register with the Maryland State Police, then existing state law actually will allow you to retain that. Now,
So the answer is yes. on that.
yes, and
Then second, to your knowledge, so the answer is yes. Does this bill apply prospectively or is it retroactive?
it doesn't have any prospective application, so it applies to existing possessions, absolutely. So
Okay.
it's retrospective application and it's reach.
Then also is, to your knowledge, is any element of law enforcement in the state of Maryland utilize or access, I'm talking even tactical teams, automatic weapons, fully automatic weapons?
Yes, there are some specialized teams that are authorized by federal law to have fully automatic weapons.
Are any of those teams operational in Maryland?
That I don't know.
Right.
But I will say the easiest way to accomplish what you're trying to accomplish here is take the federal definition, which already has a coverage for parts. And this would be a part,
Understood.
and incorporate that in the existing Maryland definition for machine gun, and voila, you're done.
It's my impression, and I think that the Maryland State Police have informed this committee that they do use automatic weapons for some of their tactical teams.
I think that's correct.
Senator Fulton.
Thank you, Mr. Chair. Thanks for coming out for your testimony. The trigger bar you spoke of, can you just give a brief, what that, why it's not defined or it's not defined, but actually what the device is?
So the way a typical machine gun works, it uses what's called an auto shear, and this bill defines an auto shear to include a trigger bar that in a way that's contrary to common usage in the industry. So an auto shear is not a trigger bar, and yet this bill defines it as a trigger bar. Trigger bar is simply a device that's connected into a certain type of handgun, which is striker fire weapons, and a Glock is a striker. S&W makes one, SIG makes one. In fact, the standard issue in the Army these days is the SIG striker fire. Right. And the trigger bar connects to the trigger and connects to the striker, which is the firing pin. It's under string pressure, and it releases a striking pin into the cartridge and detonates it. That's the trigger bar. You'll see it in the patent for Glock, for example, that there is a trigger bar. That's not normally used in a machine gun because it doesn't, the release mechanism involves a disconnect and a auto shear that holds the hammer back. There are no hammers in striker fire weapons.
Right.
So it just kind of mixes and matches terms which are not in common usage in the industry. So and it doesn't define a trigger guard, which is a
Right.
bar, I'm sorry, trigger bar, because that's not a common usage. It's unique to striker fired pistols, but even then it's not even a commonly defined term. It simply is an element of the trigger itself. You'll find the same sort of a link to a trigger in the old World War II antiques, like a grease gun or a stent gun, which likewise directly release the bolt, and that bolt act as a striker on the firearm itself. So it's very confusing in terms of just the nomenclature that's being used, and I don't think it's very well thought out, and just for that reason. Now, it's certainly better than it was originally. So, but it's kind of a mess. It makes a mess out of Maryland law. If you want to illegalize machine gun parts, and I encourage you to do so, then take the federal definition. It's well established. Everybody understands it. It's prosecuted, and it solves the entire problem. Especially in the context of where Maryland law already bans any device that increases the rate of fire. By definition, in 5-301M. What are we doing here with the new legislation when you don't need it? You could have all bases covered.
Okay, thanks, Mark. And one more question. The striker fire pistols you speak of, is there a design flaw in those?
Only Glock has this problem. There are no SIG switches or S&W switches that I know of, certainly none out in the street. So you could modify those guns by a good, smith who has a lot of tools and knowledge. He might be able to modify one of those striker fire weapons to do what the Glock switch does. But the Glock switch is unique to the Glock.
It's a Glock.
Because it's easy to do with Glock.
Okay, thank you.
So whether you call it a design flaw or something, they didn't think of it, it's certainly an illegal use of the Glock weapon.
Correct. Thank you.
Seeing no further questions, thank you very much, Mr. Pennick. With that, that'll conclude the hearing for House Bill 810. We'll now move on to Delegate Bartlett with House Bill 37. Delegate Bartlett, welcome.
Thank you, Mr. Chair. So I'm going to start with House Bill 37, Sandy Bartlett, District 32, Anne Arundel County, for the record. House Bill 37 is simply what it says. It's services for formerly incarcerated women. We want to have a commission and a pilot program. The commission would be overseen by GOCAP, and they would issue grants to 3 jurisdictions within the pilot program to start off this system of helping formerly incarcerated women. So we already have services for reentry, and you can see that in the fiscal note, but this is for formerly incarcerated women who may not be within that reentry window. They may have been out for a year, they may have been out for 2 years, but they're not incorporating back into the community or back into society. And they still need certain resources, perhaps with the local Department of Health or with the maybe some resources with respect to SNAP benefits or anything of that sort. Employment. In the House hearing, we had employers who were there and ready to hire, ready to train individuals who were formerly incarcerated. So that's what's going on with the bill. Let me talk to you all real briefly about the fiscal note, because I want to make sure I give you particular, or we have particular attention to page 5 of the fiscal note, where the analyst breaks down the funds. So $300,000 would be a grant awards. That money is already in existence. So that's not new money. We just, GOCAP would just simply issue the grants based on that $300,000. And essentially, the program is important because we have women who are sometimes heads of household, and the bill was voted out, I believe, unanimously out of the House. So a favorable vote is highly requested from this esteemed committee. Thank you.
Thank you, Madam Vice Chair. Questions from Senator Fulton? Seeing no questions. That concludes the hearing on House Bill 37. Delegate Bartlett, if you'd like to take House Bill 854.
Thank you, Mr. Chair. So first, I wanted to present to you the House Bill 854. This is Sandy Bartlett, Anne Arundel County, District 32, for the record. And House Bill 854 requires more registration facilities for individuals who are on the sex offender registry. So I am usually in my capacity working with sexual assault victims. And in fact, I think that this bill is actually helpful as well when it comes to crimes of sexual assault, because it allows the sex offenders to register so we know that they are compliant. Some of the individuals that came about so that we, their stories came about in order to create this bill, we learned that people were not actually able to register because they weren't able to get to a facility. So I worked with both the Chiefs and Sheriffs Association and anyone else I could possibly that I needed to work with, and we got the bill that is before you. We amended it to 300 jurisdictions of 300,000 or more, because I wanted to include the large jurisdictions, but I also wanted to, we started out with 500,000. I wanted to include Howard County because we've got Anne Arundel, Prince George's, and Howard County right there together, and especially in my district, they're all right there together. So I want folks to be able to register if they are supposed to register, and we found out that those large jurisdictions could handle one more facility. So on that note, I request a favorable vote on this bill as well.
Thank you, Delegate Bartlett. Any questions? Senator Fulton.
Hi, Delegate. Thanks for bringing the bill.
Sure, thank you.
I'm just curious, what's the problem with going to one location?
Transportation usually. And if you're homeless, unfortunately, you have to register once a week in person. All of the registration has to be done in person. But if you're homeless, you have to do it every week.
Okay, so not all county law enforcement agencies that are gonna meet this requirement have 2 locations.
Well, all the ones that would fall within the 300,000 population can meet this requirement of 2 locations. That's why some of the smaller jurisdictions, we didn't include them.
Okay, thank you.
Thank you.
Thank you, Senator Folden. Thank you, Delegate Bartlett. Delegate Bartlett, do you have any local bills that you need to present?
No,
Okay, sounds good. All right.
thank you.
With that, that concludes the hearing for House Bill 854. Thank you, Delegate Bartlett.
Thank you. I appreciate your time.
And then we'll just go in order here. Is Delegate Boyce here? Okay. Okay, got it.
Hi, good afternoon, Chair and members of the Judicial Proceedings Committee. For the record, I am Leslie Gray DeVivo, here presenting HB 24 on behalf of Delegate Regina T. Boyce. She apologizes for not being here. She is under the weather. HB 214 seeks to streamline the adult adoption process by eliminating redundant procedural steps. It establishes that certain legal requirements, such as issuing and serving a show cause order on prospective adoptees' parents, are not necessary for adult adoptions. Additionally, it grants the court authority to order investigations before ruling on adoption petitions for adult adoptees, but only when there is good cause shown. Moreover, parental consent is not required for adult adoptions. Adult adoption occurs for a myriad of reasons. In one instance, one of Delegate Boyce's constituents seeking to adopt her adult son faced unnecessary procedural hurdles despite meeting the criteria under the adoption laws for minors, including abandonment, abuse, and lack of financial support. Despite being an adult and having no contact with his biological parents who did not even live in the United States, the adoption process was prolonged due to the courts requiring his biological parents' consent. Another testimony that you have recounts the experience of a young woman who suffered abuse at the hands of her biological parent. The abuse took a toll on her both physically and mentally, necessitating ongoing counseling to help her cope with the trauma. Again, despite being an adult, she found herself in the difficult position of having to seek permission from her abuser for her now stepmother to adopt her. This process reopened old wounds and stripped away her autonomy, adding to her ongoing journey of healing. In cases involving minors, show cause order may be issued to notify legal guardians, including known biological parents, providing them the opportunity to object to the adoption. HB 214 removes the requirement for show cause orders in adult adoptions, recognizing adults as capable decision makers with autonomy over their circumstances. HB 214 acknowledges various motivations for adult adoption, such as inheritance considerations, nurturing relationships with adults, accessing medical information, or facilitating reunification with birth families. Through these reforms, HB 214 aims to bolster Maryland's family units by minimizing unnecessary barriers in the adult adoption process. The delegate and I thank you for your time and respectfully request a favorable consideration for HB 214.
Thank you. You did a wonderful job. Any questions on this bill? All right, please give Delegate Boyce our best. Thank you so much. That concludes the hearing for
Thank you.
House Bill 214. Just going along in order here, Delegate Holmes, House Bill 281.
Good afternoon, Mr. Chair and members of JPR. It's good to be here with you this afternoon. In front of you today is HB 281. And I'm certain that all of you have received phone calls from your constituents relevant to reserve studies. And one of the reasons why this bill is before you is because I have received calls from just about every jurisdiction across the state. And the primary reason for that, I believe, is that there is no state agency in charge of common ownership communities yet. And therefore, my office gets the calls in reference to how these common ownership community citizens issues can be addressed. What you have in front of you is relevant to reserve studies, and the bill in front of you is in an attempt to alter the previous bill that was passed requiring reserve studies. About 2 years ago, there was a blacklist put together by the federal government indicating which common ownership communities could not receive federal funding for VA loans, FHA loans, Freddie Mac, et cetera, because they did not have reserve studies. And from that has come a lot of discussion and national standards in terms of reserve studies. National standards have been addressed by organizations such as CAI, Community Association Institute. And with those national studies, from those national studies is what is in front of you right now. The amendments to the bill address issues from those national studies. And I'll go through a couple of them very briefly. What I have described in the updated version in the amendment is to identify what an updated reserve study is. An initial reserve study requires a lot more work relevant to looking at the square footage of components, et cetera, and identify each component. Therefore, it costs quite a bit more than what an updated reserve study does, because you don't need those same requirements in terms of component square footages, et cetera. So an updated reserve study, identification and definition is in this legislation. One of the other things that I have heard from communities across the state is that some communities wanted to eliminate HOAs from having a reserve study. That is not what the national studies want us to do, because, as I indicated earlier, if you don't have a reserve study, no matter if you're a HOA, a condominium, or a co-op, you can't get a federal loan. So eliminating an HOA from that would be counterproductive to those who want to get a federal loan for an HOA. The other thing that I've done in the revised that you have in front of you is I have identified certain planning funding types. Previously, I on purpose did not identify funding types because I wanted to leave it up to the reserve study specialists in conjunction with their community managers. But it got interpreted to mean that HB 107, the previous version, it got misinterpreted to mean that HB 107 meant to fully fund the reserves. Full funding of reserves is just one methodology of funding it. Therefore, I put into the new version that you have in front of you multiple different types that community managers and the board of directors can choose from to fund their reserves. With that, Mr. Chair, members of the committee, that is the primary function of what I have in front of you. And hopefully that we'll get a favorable report from all of you, including the good senator over here as well.
Thank you. Questions for the sponsor of this bill? All right, seeing no questions. Thank you, Delegate Holmes. There is opposition to this bill. Is Ms. Socha here today? Sonia Socha? You have 2 minutes to testify, please.
Good afternoon. I just want to introduce also our board president, Nancy Costello, who's with us today as well. She's not going to speak, but she came along for moral support. I represent Kings Court Townhouse Association in Baltimore County. I'm the treasurer and vice president. And I am asking that House Bill 281 as written not be passed into law with its present requirements for HOAs. There is no law in Maryland or precedents for mandating any nonprofit 501c3, 4, or 6 to be required to have a reserve account of a certain amount by a certain date. Legislating the finances of HOAs and condos is overstepping into the business of a nonprofit board. Having a reserve study and a reserve account is a must, but this should not be mandated in legislation. A nonprofit board decides when and how much is required for its account based on the needs of each organization and property and the reserve study. One size does not fit all. The state is attempting to legislate finances and plans of these nonprofit organizations without even having enough information about these groups. None of the 7,000 groups are even registered with the state. You know nothing about them. You don't know what they own, how much they manage, the size of their budgets, nothing. How old they are, how new they are, nothing. Older HOAs have 4 times as many reserve study components than newer HOAs. HB 281 will hurt these older communities in its current format, not help them. Fees will have to be raised so high it'll become a second mortgage for our homeowners. And right now, we're already owed money because of since 2008, since COVID, people can't even pay their current fees.
Thank you.
We had
Ms.
a board
Socha.
meeting last
Ms.
night
Ms. Socha.
and the homeowners were complaining about how much we increased their fees because we know that this bill is potentially down the road.
Ms. Socha, thank you
These
for
are
your,
people who can't afford this. And I ask you to step back. Let's see what happens with HB 280. And let's figure out another way to do this.
thank you, Ms. Socha, your time.
In a more
has
timely
concluded.
format and with more consulting with more of the HOAs and condos across the state.
Any questions for Ms. Socha?
Thank you.
Senator Feldman.
Senator who? Who? That's it. This bill. Ma'am, can you come back up to the mic? Did you get everything out?
Sorry.
Did you get it? Did you get through your notes there?
Yes,
I just want to make sure.
yes.
I thank you for coming out. Thank you for coming out. Ma'am, you've come all this way. Did you have anything you wanted to add just since you're here?
She said everything that
Okay.
really pretty much needed.
My quick question for you is, in your HOA, do you have any condominiums or are they all townhomes and single family?
They are all townhomes we're an HOA. We're not a condo group. And we understand that their condos may have a different set of needs based
Right.
on the construction of a building.
Sure.
But
But
our
this would
HOA
affect all
was,
of them.
yeah. Our
Okay.
HOA was created by the Rouse Company in the 1970s in the White Marsh area. So it's completely different than the new HOAs in terms of what the developer put together in the agreement with Baltimore County.
Sure.
We've been managing our little city for 40 years, so.
Yeah, no, great. And I appreciate you coming out. Thank you, ladies.
Thank you. Thank you for listening. And I hope you really take this seriously and back it up.
Thank you. We really appreciate your coming down here today. That completes the hearing on House Bill 281. Delegate Kerr, we have you here for House Bill 282. Good afternoon to you.
Afternoon, Mr. Chairman. Delegate Ken Kerr, I'm here to present House Bill 282, speed monitoring systems. Currently, with what's commonly referred to as a speed camera, that video can only be interpreted by a sworn police officer. What House Bill 282 says is that a properly trained civilian would be permitted to interpret the speed camera video and determine if a citation is in order. The bill does not change the locations where these speed cameras are permitted to be, doesn't increase fines. It doesn't alter the 12-mile buffer, doesn't change the local approval process, doesn't change the mandatory signage. All it does is change who is permitted to interpret the video. 77 municipalities don't have a police force, and they have to contract with another police force in order to have speed monitoring cameras placed outside their school zones or in work zones. Only 2 of the 77 have a relationship with the police department. Newmarket has a relationship with the Frederick Police Department, and Sudlersville partners with the Queen Anne's County Sheriff's Department. The other 75 cannot find a police department willing to partner with them in order to be able to use the speed monitoring systems within their municipality. The civilian would be trained by the vendor, the contractor, and receive the same training that the sworn police officer receives prior to his or her ability to interpret the speed cameras footage. And I would just add that this is a legislative priority for the Maryland Municipal League this year, and ask for your favorable report.
Thank you, Delegate. Senator West has a question.
Thank you, Mr. Chair, and thank you, Delegate Kerr, for presenting the bill. We are operating at a bit of a disadvantage here. We don't have lots of testimony. Our bill folders, when we had bills, were very thick, and here they're very skimpy. So I do see that on the third reading, there were 37 no votes in the House. Can you tell us who opposed this bill and what was the basis for the opposition?
There was no opposition presented at the bill hearing, and I don't serve on Environment and Transportation, so was not personally involved in the subcommittee discussions.
How did the vote go in the committee before it got to the floor?
I don't know, Senator.
Okay, I can probably figure that out.
Senator Folden.
Thank you.
Thanks for bringing the bill, Delegate. It's always good to see you.
Good to see
You know,
you,
I'm not a
Senator.
fan of a lot of these type of devices because
I
they
was
get overly.
anticipating your mic lighting up.
Oh, it was
Senator.
coming. I appreciate you being ready for it though. So the funny thing is I'm looking at a bill right now coming up right after yours, where we're looking at starting to do stop sign monitoring. So I guess where are we going to stop with this? This is, if you have crash data to support this in these municipalities, I'm all about it for safety. I get it. But we don't have that. We have a request because everybody's seeing, much like Montgomery County does, is they now see it as a line item insert into their annual budget. These amounts of revenues that they're counting on. So at what point does it become not a money grab, but become something of safety?
Well, I do have some data on crash studies. In 2016, a study in Montgomery County found that after about 7.5 years of the program beginning, the portion of drivers traveling at least 10 miles per hour over the speed limit had declined, and the likelihood of a severe or fatal crash had reduced by 19%.
How do you, I'm sorry, where do you have that data and how did they even compile that data? Because it doesn't, you can make numbers match whatever data you want. So if you're saying that all of a sudden people aren't going more than 10 miles an hour over, that's because Montgomery County has a speed camera every other road. So are you saying that this is encouraging more of that to where we have cameras everywhere to minimize this, but we don't have crash data to support the initial installment?
This bill does not increase the number or placement of speed cameras.
Actually, it does. It allows all these other areas that their county sheriff's office doesn't want to partner with them because they don't see the necessity in crash data to support it, or MDOT doesn't see the necessity in crash data to support it in these municipalities. So they're going to other places like Newmarket went and partnered. They didn't want to go. The sheriff's office was like, we don't have the crash data here in town to support what you're asking for. They're saying, well, we need the money because we got a lot of traffic going through here. So it doesn't have to be necessarily one or the other. And we'll get Frederick Police, who's not even in that jurisdiction, writing or issuing these citations, correct?
Correct. And you're correct that the number of cameras potentially will increase, but the places where they're permitted won't expand.
It's going to expand by 75 more towns, you said, potentially.
But they still have to be within a half mile of a school.
Okay, so that's my next point. We want to put these, Baltimore does it wonderfully. They do a job that is just, I mean, stellar. They'll put cameras a half mile away from a school that has nothing to do with foot traffic in the school. Edmondson Avenue, 2 hills coming down to a bridge, has nothing to do with any foot traffic within that school. But because it's within a half-mile radius as the crow flies, that is a money grab definition to the T. And because people come in one side and they go across the bridge real slow and then they start going up out of town, they start increasing their speed as they're getting closer to the school. So if this is about safety, why aren't they at the buffers of the school?
This bill has nothing to do with
But
that.
it should. That's my point. If we're really worried about safety, that's where the cameras should be. That's where these devices should be. We're spreading them out because we want high rate of travel where people are known to drive at comfortable speeds. And the area I'm speaking of specifically in Edmondson is a very wide open road that allows you to increase speed going down both sides towards the bridge. It naturally increases your speed in an area that has zero to do with the relative school a half mile away, not even on that road. So this is the problem. These are the patterns I'm seeing, and this is my concern. If we had crash data to support it, if we had concerns with these, other devices that were out there and watching children cross where, kids crossing adjacent to a school is important for their safety. Those crosswalks are very important. They need to be able to go from one side of the road to the other, especially on busy roads. But we're not putting them there to slow people down. And we're not putting them at a threshold, not even 12 miles an hour over. At that point, put them at 1 mile an hour over. That's the law. But we're not looking at it through the safety lens. It becomes a money grab lens when we keep installing them around. Now your bill offers to have someone that you're saying is trained the same as a police officer, which I'll beg to differ on. They may receive the same training from the camera company that the police officer receives, but they don't receive the same background and training in vehicle law and Maryland law that police officers receive. And the interpretive measures of what is required and defined in the certain articles of the traffic law. Is that agreed?
Yes, but we're only talking about one specific aspect of vehicle law. They wouldn't need to be trained in all aspects of vehicle law if they're only interpreting.
But they're trained in none.
And there's no specific training on speed cameras within law enforcement academy training either.
No, but they're trained in traffic law. They're trained in what 21-801.1 with vehicle speed law means and how it changes with school zones and work zones and the other variables. So this continues to be a pattern here, and we keep planning more of these. And I just have if we have safety and crash data to support it, I'm in support of it all day long. But this is not the method. Maryland is looking at, we got another opportunity to pull some money from our taxpayers by other ways. Right now, we're looking at a bill for work zones. The lieutenant governor comes in and wants $290 per citation.
All right, let's stick
Okay.
on the bill.
It's relative to the bill. It's very relative. So, thank you.
Thank you. Any other questions for Delegate Kerr? All right, thank you, Delegate Kerr, for joining us here today. That concludes the hearing on House Bill 282. The next on our list is the Prince George's County Delegation Bill. Delegate Healy, good to see you.
It's good to see all of you too. House Bill 364 is a local Prince George's County piece of legislation. It was significantly amended in the Environment and Transportation Committee, and its scope was reduced significantly, and a sunset and a report was added. So this is the original bill was much broader, and it was unanimously supported by the Prince George's delegation. A little context. I had put a similar bill statewide in Environment Transportation in previous years. It did not pass. But my district and Prince George's County really wants something along these lines. And so I put it in as a local bill this year. It had got unanimous support from the Prince George's delegation as submitted. With the changes, let me explain a couple of things, the bill now does. As amended, House Bill 634 authorizes on a trial basis the use of 10 stop sign monitoring systems by the Prince George's County to enforce for failure to come to a stop at intersections governed by stop signs in the county. The systems may only be used at locations approved by the county council. The county must prioritize placement and locations in municipalities that have high rates of violations. The trial basis is set to last for 2 years, after which the County Department of Public Works and Transportation must report to the governor and the General Assembly on the performance of the systems and the results of the program. So I'm in a mixed person because I really wanted the original bill, but the committee narrowed it significantly. It is now going to collect data, which I know I just heard that the senator is very interested in. And at the end of 2 years, it will have a sunset review and perhaps the concerns of the people of Prince George's County will be addressed permanently. But the other thing, I just wanted to mention one specific thing that happened November 20th, Monday of Thanksgiving weekend, in the little town of Riverdale Park, Riverdale Elementary School, 100% walking school. Every kid walks there from their neighborhood. 8 o'clock in the morning, in the crosswalk, walking to school, 2 children with an adult member with a family of one of the children were hit by a van, and the 2 children died, and the adult was very seriously injured and hospitalized. If there had been cameras at those stop signs, we would know exactly what happened. There would be pictures of whether or not the stop signs were run through. People in Prince George's County know that stop signs are ignored. People run right through them all the time. That's why they have been pushing hard for this kind of legislation for several years. With all that in mind, I ask you for a favorable report on House Bill 364, and I'm glad to see a senator from Prince George's County. Good afternoon, and I'd be happy to answer any questions about this legislation.
Are there any questions? Senator West.
Thank you, Mr. Chair. Nice to see you, Delegate Healy.
Thank you.
Welcome to our side of the street.
Happy to be here.
So again, I'm operating under disadvantage. We have almost none of the testimony that was offered on the other side. And I see that there was 31 negative votes on the floor. So obviously there was some opposition to this bill. Can you tell us where the opposition came from and what it consisted of?
Well, as I said, this had several public hearings. It had a public hearing in Prince George's County, which resulted in a unanimous support from the county delegation.
And it's a local bill.
But this is a local Prince George's County bill.
Okay.
It only affects Prince George's County.
Why were all these out-of-county people opposing this?
I think there are people who have philosophical issues with speed cameras, period.
Oh, that's what it was.
And I think that expanding it to stop signs is something that they're just not comfortable enough with. But we're asking, as the Prince George's delegation, and you can ask the Prince George's senators as well, this is something we really need in our community. Maybe they don't have these kind of issues in other counties, but we do.
Okay, great. Thank you very much.
Thank you.
Being that there are no other questions, we're finished up with this HB 364 and move on to HB 440. Thank you, Delegate Haley. It's always great to see you. And speaking on behalf of the Charles County delegation, we have their chair, Delegate Deb Davis. How you doing, ma'am? Welcome.
Thank you so much, Mr. Chair. For the record, my name is Deborah Davis. I'm from District 28. I am the Charles County Delegation Chair. I come to you with HB 440 regarding Charles County exceptions for golf carts on Cobb Island. Cobb Island is a unique place in Charles County. It's a peninsula with one bridge leading to it. So ergo the name Cobb Island. We've had a public hearing. We've had unanimous support from the Board of Commissioners, and a total support by our delegation. This bill would simply allow golf carts to be operated on highways in Cobb Island, posted speed not to exceed 30 miles per hour, between the hours of dawn and dusk, operated by someone with a driver's license, and they had proper lighting. We respectfully request a favorable report.
Are there any questions? Senator Foden? Hey, thanks for coming out, Madam Chair. Can you do me a favor? Can you do something about that Delegate CT Wilson, please? I mean, that's all I'm gonna ask. You know what I'm dealing with. That's all I'm gonna ask. So thank you. I appreciate it.
Yes, sir.
Help this out. All right, being that there aren't any other questions, we'll finish off with House Bill 440 and move on to House Bill 687. Floor is yours, Madam Chair.
Thank you, Mr. Chair. Again, my name is Delegate Deborah Davis. I'm Chair of the Charles County Delegation. I'm here to present HB 687. It is Charles County Governing Bodies of Common Ownership Communities Member Training. As I've stated before, we've had a public hearing on this in Charles County. It has the full support of the Charles County Board of Commissioners, the full support of the entire delegation. And we've run into a problem in Charles County, as a lot of jurisdictions have, with board members of common ownership communities not knowing their responsibility. This bill would simply ask them to complete training within a certain amount of time. We respectfully request a favorable report.
Are there any questions? Hearing no questions, thank you, Madam Chair.
Thank you.
Thank you, Mr. Chair, members of the committee. My name is Todd Morgan. I'm the delegation chair for St. Mary's County. I'm here to introduce today House Bill 683, another golf cart bill. Basically, this golf cart bill was reviewed last year, has unanimous support of the St. Mary's County Commissioners. And what it basically does, it will allow the St. Mary's County Commissioners to choose roads that they feel will be accessible for golf carts. We have a lot of waterfront community, a lot of waterfront properties. They're dead end roads, hook roads, things like that. So we're looking for a favorable report to this from this committee today on HB 683. And just preface this a little bit, as you heard just now from Delegate Davis, she had HB 440. But this afternoon, you guys have the opportunity to vote on Senate Bill 316, HB 43 from Senator Bailey, Delegate Stewart. You vote those things positive. You don't have to worry about Ms. Davis and myself coming back. Thank you.
Thank you, Delegate Morgan. Do we have any questions? Hearing no questions, Delegate Morgan, you're good to go. Thank you, sir.
Thanks, guys.
All right. I see Delegate Attar. Oh, there you go, Mark. There you go, Delegate Fisher. I didn't see you behind the podium, Calvert County.
Yes. Oh, yeah. Thanks. So good afternoon. For the record, Delegate Mark Fisher for HB 766 on behalf of the Calvert County Delegation, Mr. Chairman, and members of this esteemed committee. This is basically for Calvert County roadside solicitation of money or donations, prohibition. The reason is very simple. It's because Calvert County has one way in and one way out. And so when you stop at a road, you're stopping at a highway. If you're in the middle of a median, you're in the middle of a highway. And it's supported by Senator Michael Jackson, the Calvert County Senators, and Senator Bailey. And so everybody has a kumbaya moment and loves it. Can't believe it.
The end of your testimony, sir?
Yes, sir.
All right. Are there any questions? Kumbaya.
Thank you.
Thank you, sir. All right. Next up, we have Delegate Embry, House Bill 943.
Mr. Chair, members of the committee, good to see you again. I will be very brief. This is not a cross-file bill. This is Elizabeth Embry here in support of House Bill 943. Just as a background, we have passed many laws in the state, which are wonderful, that have protected the identity of defendants whose cases have been expunged. That's very worthy and important. But as a result, vast amounts of data are now prohibited from disclosure in any form to researchers, the media, anyone who wants to know if the criminal justice system is working. So this is a bill that I've worked with advocates on. The judiciary has now removed their opposition. I've worked with them as well. That would allow de-identified data to be available if it's been expunged for analysis or for other research purposes. So I do have one amendment. The judiciary has asked, they have a new system coming online that will make it easier for them to comply. So they've asked for a later effective date. I did distribute that to the committee today, and I can do that again if it wasn't received. But again, this is just trying to make data available for anyone who wants to know if what we're doing is having an effect, if we want to look at conviction rates or how long people are staying in prison, bail reform, you name it. This makes it possible because up to 30% of cases are expunged because of null process automatically in many cases. And so that really removes the denominator from any real analysis of what is happening. So with that, I will ask for your favorable report and answer any questions you have.
Thank you. I see we have Senator West who has a question.
Thank you, Mr. Chair. It's nice to see you, Delegate Embry.
Thank you. I'm sorry I missed you at our judiciary today.
I was just over there. You weren't there.
I'm sorry.
But I urged them to pass your bill as well as mine. So we dealt with a bill here not too long ago dealing with the red flag law and making data from that available to researchers. And when the question was raised whether or not the data could be de-identified, the answer was it's too complicated, too expensive. So the data is being made available to researchers, even though the names of the people and their psychiatrists, et cetera, are all clearly visible in the data. But you just indicated that in this case, you're going to be able to make this data available on a de-identified basis. What makes this situation different from the situation that we dealt with not long ago with respect to the red flag bill?
I don't know enough about the extreme risk protective orders and how that data is stored. And the judiciary did say, and that's the reason for the later implementation date, that it will be easier once their new data management system is online. And so I don't want to speak for them. They did say it would be more challenging until that's fully up and running. But this would be providing, for instance, if you wanted to know all about every armed robbery in your jurisdiction, you'd be able to get every detail, you know, when it happened, what the charges were, but you would not have any information about the defendant. That information is stored in the Maryland case judiciary system. Currently, they're able to pull that data for non-expunged cases.
No, I understand it, and it sounds
but I
great.
don't know I'm sorry, the answer is I
great.
don't know why that's not possible.
My guess is that there are far more expunged cases which will need to be scrutinized and purged of this kinds of identified data than there are red flag cases. There's a relatively few number of red flag cases, but in that case, it was thought to be too burdensome to de-identify the data. But in this situation, the judiciary feels that with all of these expunged cases, they can successfully do this work?
It's a little bit different. So this would be providing sort of an Excel spreadsheet with data fields pulled from the system. This would not be providing the actual case records, because going in and expunging a case record, picking through and you know, deleting, redacting, that's enormously time consuming. And that is not what this bill does. This is just allowing the provision of the data points, sort of a spreadsheet of the information.
I see. Okay, thank you.
Are there any other questions? Hearing none. Thank you, Delegate Embry.
Thank you very much. Thank you.
All right, Delegate Weibel, I'm sorry, Weibel.
Thank you, Mr. Chairman. Good to see you and other members of the committee. Delegate Weibel, please present House Bill 967 for the town of Keedysville, parking vehicles restrictions. House Bill 967 is in the same format as the bill you all passed last year for the town of Sharpsburg. Both towns are adjacent to each other. They're small towns, rural communities, intent on preserving their historic nature of their downtown core. This bill simply adds the town of Keedysville to the list prohibiting parking of tractor, trailer, school bus, and passenger vehicles on any street or highway within the town limits. It's necessary because the town doesn't operate its own police force. And this would allow for enforcement of parking restrictions by the county or state police. I ask for a favorable report.
Thank you. Any questions? Hearing no questions. Thank you, sir.
Thank you very much.
All right. We're going to skip down to House Bill 1310, Delegate Attar.
Thank you, Mr. Chair, Mr. Vice Chair, and members. For the record, I'm Dahlia Attar, here presenting House Bill 1310. This bill would establish the Youth Violence Review and Response Team consisting of several agencies that are listed in the bill, and they're responsible for identifying high-risk youth, analyzing root causes and patterns, and providing recommendations that would reduce the amount of high-risk youth, and then they're responsible to connect them with the services that they need. High-risk youth is defined in the bill as a victim of gun violence, a witness to gun violence, or a family member of a victim of gun violence. This bill we amended significantly in the House to ensure that there are appropriate protections to ensure confidentiality, and it passed the House of Delegates unanimously. It's also a priority for Mayor Brandon Scott, and I ask for a favorable report. Thank you.
Thank you, Delegate. Are there any questions? Hearing no questions. Thank you. All right, now next we're going to go to House Bill 13, Delegate Robin Lewis. House Bill 13.
Mr. Chair, esteemed members of Judicial Proceedings, I'm Delegate Robin Lewis here on behalf of House Bill 13, Residential Property Affordable Housing Land Trusts, Authority to Establish Condominium Regimes. This bill might sound familiar to some of you, as it's a cross-file of Senate Bill 199, which was introduced by your esteemed Vice Chair, Chair Walt Stryker. The bill before you is in the exact same posture as its Senate cross-file, which was introduced again by Chair Walt Stryker, and that passed the Senate unanimously on February 22nd. I'm happy to take any questions.
Any questions? Hearing no questions, thank you.
Thank you.
All right, we're going to now go to Delegate Williams for House Bill 550 and then let her follow up with House Bill 833.
Thank you, Mr. Chair, and members of JPR. House Bill 550 may seem a little similar in a lot of respects. There was a cross-file with Senator Carter. Senate Bill 11 is the cross-file, which I believe this committee voted out. House Bill 550 has been dramatically amended, and there's even an amended fiscal note on this. And so now it's basically a procurement bill. What this bill now simply does, it requires, and there's a slight difference between the House version and the Senate version, which we are perfectly fine with adding in kind of the additional language in the Senate version. But basically now the bill just simply requires the Department of Public Safety and Correctional Services to include system upgrades that would allow for automatic expungement of charges and partial expungement of charges in any vendor contracts that are being negotiated at the time this act takes effect. I think the difference between the House bill and the Senate bill is that the Senate bill also includes the the judiciary with regards to that procurement. The Senate bill defines partial expungements. It doesn't define automatic expungements, which since we're talking about both automatic and partial expungements, maybe it needs a definition for both, or maybe just the partial expungement language in the Senate bill just needs to come out. But the reason we didn't initially include the judiciary in the House bill is just because with MDEC, they actually do have the capabilities, from our understanding, in conversations with the judiciary, they have the capabilities with the current system of MDEC to do the automatic expungements and the partial expungements, but we're more than happy to add the judiciary into the House bill just to cover our bases. And so I'm happy to take any questions that you all may have.
Senator West.
Thank you, Mr. Chair. We've dealt with these partial expungement bills for a couple of years. And the judiciary always comes in and says, based on our current system, it would be extraordinarily time consuming to go through each of these files in order to expunge everything relating to one charge, but leave the other charges intact. Is this bill different from the ones we've heard before in some way, which makes it easier for the judiciary to expunge these?
Well, so the bill that I introduced, the last time I was introduced, I think was in 2021. And at that time, MDEC was not fully online and rolled out at that time. So the fiscal note at that time was much higher because not only did they need only the pins for the individuals to be able to, do the redaction, like you mentioned, but also the operational system. I think with the vendor that the judiciary has now, they have the technological aspect to be able to accomplish this, but you are correct. They are still stating that they do need some additional personnel in order to be able to accomplish this.
Okay, and I think that's why the bills that we've received sound very appealing. I think everybody would like to do it, but we always are responding to the judiciary, which says it's unworkable unless they are given huge numbers of additional staff members to do all this work.
Right. And so, and the reason with the modification of the bill, it actually pushed those costs out. So that's not something that would impact the budget presently or even next year's fiscal budget, because the other side of this is the Department of Public Safety and Corrections with CJIS does not have the software or the technology to do it. And so it doesn't make sense for the judiciary to have the technology, but CJIS is not capable of doing it. And so what this bill does would require the Department of Public Safety and Corrections when they have to update their vendor contract for the current CJIS system to update it so that the system would be able to do that. And then at that time, we could have a further conversation with the judiciary on the pins that they may need in order to handle this.
Okay, I was going to say that when we got the bill this year, we changed the bill significantly.
Yes, and the House bill is very similar to the Senate bill that you all passed out of here. It's just some slight differences, such as I mentioned, the definition of partial expungement is what's in the Senate bill, and the Senate bill also mentions the procurement by the judiciary as well.
Right, so both this bill and our bill are basically procurement bills now.
Correct, that is correct.
Got you. Thank you very much.
You're welcome.
Are there any other questions? Hearing none, that brings the hearing for this bill to an end. You can now move on to House Bill 833, Madam Chair.
Okay, thank you, Mr. Chair. House Bill 833, I like to say, is a simple bill. And what this is basically the effort with this bill is basically to really try to keep children with their parents as much as possible whenever a parent is undergoing substance abuse disorder treatment. We did make some amendments to the bill before it came out of the House so that it only applies to inpatient treatment services. And so we removed the outpatient portion of the bill. We also made some additional amendments to the bill just to kind of tighten up the language to make it very clear that this would only apply in facilities that actually have the beds and services to be able to allow children to be there at the facility and the presence of the child's parent for the duration of the treatment. And so that's really the gist of this bill. There's very little opposition to this bill because we did work. The amendments kind of dealt with some of the concerns that were initially raised by the Maryland Association of Social Workers, as well as some other entities. And so, I mean, it passed out of committee 21-2. It passed out of the House 135-3. And so, but I'm happy to, and so I think it's, I think we addressed most of the concerns that were raised on the House side with the amendments.
Yes, Senator Kelly.
Thank you, Mr. Chair. Thank you for this bill, Delegate Williams. I really, really like it. So I just want to, I thank you for thank you for noting that you addressed the concerns raised by the social workers. And I just want to ask you a question about the really strong, I think, excellent letter of support from the Department of Human Services that talks about how this bill is really aligned with the family first, family-centered model of practice and supporting parenting. This is something this committee has been really concerned about this year, making sure that children can stay with their families when possible. So if you could comment on that, I would really appreciate it. And hopefully we can vote this bill out.
Yeah, we spent a lot of time over the interim working with the Department of Health as well as the Department of working with DHS as well, and coming up with the language as well as with OPD and the with OPD and other stakeholders before we even drafted the bill, just to make sure we were really covering our bases and we weren't getting into territory that would be absolutely unworkable or not aligned really with the best practices. And so that's why we really wanted to make sure that the social workers were comfortable with the language of the bill. And this is something that there are already facilities here in the state that have these treatment facilities. So in terms of the fiscal note, these facilities already exist. And so that's all that we're just really kind of codifying best practices here with this bill. You're welcome.
All right, are there any other questions? Oh, yep, Senator West.
Thank you, Mr. Chair. So on this one, I note favorably that it passed overwhelmingly in the House. But now I'm looking at the judiciary's opposition.
Yeah, and that's new. They did not have any opposition in the House, and it's just really a one paragraph thing, which I think maybe they might be misconstrued. And I do have Ms. Kafani here with the Office of the Public Defender. I think what they're looking at is actually kind of existing law currently in the code, and I don't know if she's able to kind of address that in a little bit more detail.
Let me read what they say and then ask you, one of the two of you, to respond to it.
Yeah, I mean, I have the letter here. They're talking about the presumption that's being created.
They have a problem with establishing presumptions as a matter of law.
Yeah, but I think the presumption is actually already in the law, and Ms. Kafani can kind of speak a little bit better if that's okay, Mr. Chair.
Sure.
That's fine.
So in Courts and Judicial Proceedings 3-818, there is a presumption kind of in the opposite, but the presumption is within 1 year of a mother giving birth to a child that is exposed, it would be a presumption that the child is not getting proper care and attention if the parent is not engaged in treatment. So this presumption would go under that same statute, and it is basically saying that if at the time of birth the mother is enrolled in treatment and is enrolled in this mother-baby program, the presumption is that the child is getting proper care and attention. So it's kind of stating it in the opposite, but it is doing the exact same thing, making sure that within that time frame, the mother is actually getting treatment and therefore is allowed to have the baby with her.
Well, I'm worried about the public policy decision to have a presumption in the first place. So what the judiciary says is the judiciary notes the difficulty of presuming at such an early stage of the case, when the court may have little information, that there's no emergency situation. The court also only has limited information about a treatment program's child-specific programming. It's difficult to presume that the child is getting proper care and attention, and that child welfare cases are extremely fact-specific.
I would note that
in terms of public policy, is it really good to presume that the children are well off? Wouldn't it be better to let the facts come out in court and then let the judge make the decision rather than have a presumption operate from the get-go?
Well, the presumption does not prohibit the social worker from removing the child if the facts of the case make that something that the worker thinks that they should do.
Yeah, but you have to overcome the presumption.
Right.
The presumption, almost like a barrier. And in order to win, you have to climb over the barrier with the facts of the case, instead of simply presenting the facts and letting the judge decide based on the facts whether or not the child should stay with the parents or not.
Right, but the presumption really is already there because it's a very similar presumption as in 3-818, and the same facts that one would have to come into court and prove with 3-818 are the same facts that one would have to come in and prove under this particular bill. So I would also say that these are the same treatment facilities that the court in these cases are ordering mothers to attend anyway. This is already happening in some jurisdictions where the social workers are coming to the hospitals and offering these services to mothers in order to keep the babies together. What we're really trying to do here is create a presumption so that the practice is uniform in every jurisdiction. But again, in terms of the court's familiarity with these programs, these are the same courts that families before the court are being referred to anyway by the same Department of Social Services, that once the family comes before the court, will present this as a treatment option. And in most cases, the parents are being referred to these programs, are going to the programs, and the child is still being removed. So again, I understand the idea of not creating the presumption, but what we really want to do and what is in line with best practices, as you heard, and even the Department of Human Services, is for children to stay together and encouraging these parents to go to these treatments. The harm is already done if there is no presumption and children are being removed just to go to court and say, oh, they are in fact in this program and their child is able to go there, and we should keep them together.
Okay, last question. Is this presumption, in your view, an essential part of this bill? If we were to take the presumption out, would the bill still be worth passing without the presumption?
I think it is, because it will encourage, again, when social workers are reporting to hospitals and evaluating these cases, it is encouraging them to allow babies to stay with their parent and be placed in these treatment centers, which is essentially what we want. Right now, they're encouraging the parents to be taken there, but once you remove the child unnecessarily, because you have to remember, these are treatment centers that are designed for this purpose. They're designed to keep parents with their children. They, provide 24-hour supervision, all of the services needed for the mother in terms of treatment and for care of the baby. So that's what they're there for. Without that presumption, we will continue to see the same thing in some jurisdictions where even when the mother is enrolled, or even if she agrees to go to the program, she's still separated from her child for 3 to 18 months when she shouldn't be at that point.
Okay, thank you for your answers.
Thank you.
All right. Okay, Senator Sidnor, and then Senator Kelly, and then I have a follow-up question after that.
Thank you. Good afternoon. When you're over in the House, was the National Association of Social Workers, were they in opposition, or is this new?
They initially were, but with the amendments, they no longer are.
So, and I'm gonna read one of their paragraphs, and you can tell me if the bill in its current state addresses this concern. It says HB 833 will limit the protection of shelter care for children whose parent is receiving treatment in a residential or outpatient substance use disorder treatment program with beds or services for patients' children. Substance use, and then it goes, let's see. Moreover, legal shelter will protect the child by restricting the parent from taking the child from them if exiting the program emergently. Recovery rarely has a straight trajectory, and relapse is well known to be part of recovery. However, the bill was changed. I mean, is that addressed in some manner?
I think so. So one of the things is that we removed outpatient treatment services. And I think that's part of where some of the concern was raised by the social workers, because with outpatient treatment, there aren't as many guardrails with regards to the treatment services that the parent is receiving as you would have with inpatient treatment services. Also with the inpatient treatment services, you have staff there 24/7 that is able to not only monitor the parent to make sure that the parent is adhering to the treatment program, but also to ensure that the child is not being harmed in the process.
I'm sorry, the sentence that I skipped, it says substance use disorder treatment programs are neither programmed nor staffed to assess for child safety. Is that something that's addressed?
I think that was their concern was with the outpatient services. Yes.
Okay, thank you.
Senator Kelly.
So much. And I think you kind of got at the first part of my question. So by removing outpatient, for a child to go back with their parent, they have to be in a residential treatment program where the child can live with them.
That is correct. The facility has to have a setup where the child can live with them.
Thank you. And then, so my next question is kind of a big question, and I am not sure, prompted by the conversation back and forth with Senator West. And I'm not sure you can answer this now, or maybe you want to bring this information back to the committee because it's a big picture question. You may not, and I'm sorry, but and I'm sorry, I'm the one asking this question. There are only 15 women in the Senate. There are only 3 women of color in the Senate. And so I'm here asking this question to you, but I went to a conference this summer at the Center for Reproductive Rights, and this topic behind this bill was a tremendous amount of the conversation we had in terms of disproportionate impact on women and children and families and communities of color that these programs have. And I love your bill because it is addressing exactly what we discussed there and moving us in the direction that we as a state have been trying to go. So can you sort of address the disproportionate impact on families of color and potentially bias that might, I'm not saying there's bias, but certainly if we're making the case that we need to keep that presumption in, that we're moving in the direction towards sort of addressing some historical injustices?
Yeah, I think that's correct. Unfortunately, this bill is addressing the large chunk of the population that unfortunately falls within this bill are women and parents of color. And so one of the things that we are trying to do is kind of really eradicate some of the wrongs that have happened over the years, where we have seen we just have this presumption that if someone has a substance abuse disorder, they must automatically be a bad parent. And what we're trying to do and say with this bill is that just because someone has a substance, now we know that a substance abuse disorder is a disease. It's not because of bad behavior, it's a disease. And so we have an individual who is trying to get a cure for this disease that they're undergoing, and they shouldn't be penalized by having their child removed from them because they're trying to do the right thing in our society and getting the help that they need to deal with the disease that they're trying to overcome. You're welcome.
And for that follow-up question that I had, how does this work if you have 2 parties in a custody matter, mother and a father going against a custody issue, and the mother, for instance, in this particular issue, goes into this treatment program?
Mm-hmm.
Would this still allow for the courts to put the child with the father?
Yeah, it doesn't prohibit it at all. And I think one of the things that we're trying to prevent is the child not necessarily not going with the father, but going into foster care or some other type of care that is outside of the family unit. And so this would not prohibit the father from being able to visit the child, from, if there's a visitation order in place, still having those visitations take place. So there's nothing about this bill that would modify that at all.
Okay, thank you.
Okay, you're welcome.
Are there any other questions? Senator Sidnor.
And again, I was I had a conversation a couple of days ago with council, and I'm trying to make certain that I'm understanding what's going on. I was just watching television just a few days ago, and there was a story about I'll say a man and a wife. There was a man and a woman who were laying on the beach. I believe they were so drunk that they were on the beach, passed out, and law enforcement had to kind of holler to get them up. And they had a child on the beach with them, so the concern was that the child went into the ocean. Ultimately, I think the child was actually found back somewhere safe. But one could say that if you're drunk, if you're so punch drunk that you're out on the beach and somebody has to really yell to get you up, you probably have a substance abuse issue. They were arrested for, I think, child neglect. That's not this. This is somebody who was in a residential facility who was attempting,
correct,
or struggling and trying to get better.
Clean. Correct.
Okay.
Yes.
Thank you.
Thank you.
All right, any other questions? Seeing that there are no other questions, Madam Chair, thank you for presenting House Bill 550 and 833.
Thank you. Thank you very much.
Okay, we're now going to move forward to House Bill 970, Delegate Wells.
Good afternoon, Mr. Chair, members of the committee. For the record, I'm Delegate Melissa Wells here to testify on House Bill 970. House Bill 970 is a continuation of legislation that we passed last year that requires landlords to give specific notice of rental increases to tenants. But what we did not include in last year's legislation was just some clarifying language that just provides protection of late notice to the tenant. So what this bill this year does, it aims to address this by saying that if a landlord does not give proper notice, they will not be allowed to raise the rent for that upcoming lease term, the upcoming lease renewal period. And that they cannot take any adverse actions because of their failure to properly notify a tenant. I want to just also stress that we did work with some of the landlords, MMHA, AOBA, just to clarify that this would only impact landlords that have not done it, and to clarify that this would not preclude them in perpetuity from ever raising the rent, because there was something in the language that that gave off that impression. So we wanted to make sure that we clarify that, because that is not the intent of this bill. And so with that, we are asking for a favorable report on House Bill 970.
Are there any questions? No questions? Well, thank you, Delegate Wells. We appreciate you for coming in today. And we're now going to move forward with, let's see, House Bill 978, Delegate Young.
Thank you, Madam, I'm sorry, used to my chair. Mr. Chair, members of the Judicial Proceedings Committee, it's always a pleasure to see you all. Delegate Young here on behalf of House Bill 978. It's a very simple bill. It simply asks the courts to report on the text messaging system that they have started. The bill began as a bill requiring the courts to create a text messaging system. In conversations with them, we learned that they already are creating one, but that they are still building it out. So right now, I believe that they're only doing certain district court cases. So what the bill simply asks, and the courts are in agreement, is for them to report on what they're already doing, give certain parameters about what that is, as described in the bill, and then look at what the future prospects are, with the hope and anticipation that once we see what the future prospects are, we can work with them to make sure that it fully comes to fruition. And hopefully we won't need any legislation, but if necessary, then we will come back in the future with some legislation. And that is the bill, and urge a favorable report.
Are there any, yep, Senator Sidnor.
Thank you. And hello. What is this? Because I'm not aware of the text messaging system. What is that system being designed to do?
I mean, it's very simple. I mean, if you sign up for a whole host of things, I can't really off the top of my head think of one, but there's a lot of situations where you might sign up for a text message system, or you might be getting text messages. I get a lot of text messages from the Democratic Party these days asking for money. But the point being that ultimately what the goal would be is that if you receive the summons in the mail, you would be able to sign up to receive text messages when you get updates for your court cases. So the goal being to reduce failure to appears, therefore saving the court time with cases that might get rescheduled, et cetera. And of course, saving individuals from the potential of having a warrant put out for their arrest. But again, it's simply, you would be able to sign up when you get your summons is the goal. Whether you go to a website, whether it's a QR code, you opt in to getting the text messages, and then the courts would just send those updates following that.
So the system that's being contemplated by the court and that you were contemplating in your bill is something for litigants, or I mean, they're the parties who will be the ones signing up for this service?
The initial thought process was focused on the parties, but certainly, given technology, I don't see where it would be difficult for litigants, attorneys, anybody that's really involved in the case to be able to get those updates. And in theory, anybody interested in the case could theoretically get certain updates as well.
Now, I went to a school that's all about theory. So, I mean, theory is all good and everything. But I'm curious, what did the court tell you that their system is going to do that caused the whole rewrite of your legislation?
Well, what they're currently doing is focused on, I think, the parties. And I don't want to speak for the court on that. So I would actually.
But it was good for you with their explanation.
If it was simply, right now, it's good for me. Right now, they said they're working on something. I don't want to disrupt the work that they're already doing. So we'll go ahead and let them do that and get this report. Once
Gotcha.
we get the report and we know what the future prospects are, if there's other adjustments that need to be made, that's a conversation I would be happy to hopefully bring back before you all in a future session.
Thank you very much, sir.
Appreciate your question, sir.
All right, are there any other questions? Yep, Senator Carter.
Thank you, Mr. Chair. Delegate Young, thank you for bringing the bill. I am familiar with the system being utilized quite a bit, particularly when someone is arrested and they sign up for it and then they get notification for their court dates and hearing dates. I think it's generally an effective tool if people sign up for it. My question is it currently being used in every jurisdiction at the moment, do you know, or are there still areas where this is not available?
I'm not familiar with all of the jurisdictions that it's available. But so that's a question I would like to follow up with you on. But I do know that it is not used in circuit court.
Okay, thank you. That was it. I think it's generally a pretty good program. I mean, only thing is that it's hard for people to say they didn't know. You know what I mean?
Right.
All right, any other questions? Hearing none, thank you, Delegate. I appreciate you coming in. We're gonna now move, we got two more bills left, so we're gonna have the Howard County delegation come on up. It's like Delegate Terrace is here.
Thank you, Mr. Chairman. I appreciate it. So good afternoon, Chair Smith and members of the esteemed Judicial Proceedings Committee. For the record, I'm Delegate Jen Terrace. Thank you for this opportunity to present HB 1356, which is a local Howard County delegation bill about transparency in local elections in Columbia. This bill passed delegation unanimously, and the committee should have the delegation letter of support. HB 1356 requires candidates for village elections to report who gave them money and what they spent their money on, and it applies only to Columbia Association elections. So what is a village and why is this necessary? Columbia is run by the Columbia Association, which is divided into 10 villages. Each village elects a board member and each also elects a representative to Columbia Council. For many years, these have been just teeny tiny elections. Nobody cared that much about it. It was hard to even get people to run for it. I think the most I ever knew somebody spent on one of these elections was like $25 or $50 at Kinko's to make copies, but that was even rare to hear about that much spent. I also heard somebody got pencils printed on at some point and handed those out. So basically those were small elections, but about 3 years ago, it became clear that someone or some entity was putting a lot of money into CA elections. I personally received 4 fancy mailers mailed to me. I know other people got 6. You guys know what those cost. So that's a huge increase in money that was going in. So I've heard estimates of about $100,000 that went into that election. But the exact amount isn't known because we have no current requirement that anybody report on these donations. So Howard County doesn't have any municipalities. Columbia is really basically the closest thing we have to one. And while Columbia Association is technically an HOA and not a municipality, it really operates much more like a corporate city with over 100,000 residents and more than 40,000 households. You might even call it an HOA on steroids. And so Columbia Association is actually, it's probably it would be the biggest if it were incorporated, the biggest, second largest city in Maryland. Columbia Association has a $70 million budget. They have mandatory dues that residents and employees and employs 1,100 people. And they make a lot of significant improvements. Decisions, including it executes liens, has bonding authority, manages open space, including some 23 pools and four indoor pools, grants easements and leases, has 100 miles of pathways. So it's really a lot more like a city than it is like an HOA. And so basically HB 1356 will help provide residents of Columbia with the information they need to as to where campaign money comes from and how it is spent by the candidates in order to aid voters in evaluating those who seek office. I respectfully urge a favorable report on HB 1356.
Excellent. Thank you very much. Delegate. Questions from the committee. We have a question from Senator Sidnor.
And thank you very much. I've always been somewhat confused about CA and how it operates. So the question that I have is, why is it necessary for the state pass a bill in order to govern essentially a nonprofit rather than a local government, the local government to do this?
So well, Columbia Association is not a city, so they can't pass legislation like that. Now, they could individually, each of the villages run their own election and they could require it themselves. But I think the point is that once you have money in politics, that gets harder and harder to do. And so,
I understand all that. What
I'm
trying to
just having
understand
trouble
is
hearing you. I'm sorry, Senator.
why is the state doing this? That's what I'm trying to understand, because it's essentially, it's a nonprofit, right?
It is a nonprofit.
So, and again, I guess I'm trying to understand, why is the state involved in this?
Why is the state? Well, so first of all, as you probably know from this committee, we often have legislation that impacts, in fact, you've had several today, bills that impact HOAs. So we do regulate HOAs. The other thing that I would say is that Columbia essentially operates as a corporate city, right? It doesn't really operate as much as an HOA. And you probably also heard bills here in this committee where Columbia Association said you should exempt us because they're basically this big monster HOA, 100,000 residents, 40,000 households. So I would say the reason, why is it necessary? I mean, I think it's necessary because we saw money in politics. We know what money in politics does, and we have regulations on that at the state level. And basically, they operate as a city. They have the bonding authority.
Is this something that they probably are not interested in doing themselves, therefore?
No, I wouldn't say that. I would say, well, Columbia Association doesn't pass any laws. They're an HOA, so they wouldn't pass a law that would affect all the elections in CA. Each village could make a decision individually to require a report. I know one of the villages, Oakland Mills, didn't require it, but actually offered it as an option, and that actually was somewhat fruitful. But I think the idea is to have some uniformity across Columbia.
And the Columbia Association itself can't do it, but the villages can.
The villages are responsible for their own yes, Columbia Association doesn't pass any laws.
Gotcha. Okay, thank you.
I'm sorry, yeah, sorry. So because I was thinking the same thing, like, so why is the state doing this? Because it's a nonprofit entity that could just establish its own rules and regulations itself. And then the bill does create a lot of the definitions of disbursement, donation, village. Are these like cross-referenced anywhere else? Or are they just new definitions that we're creating in the statute?
Okay, well, in terms of it being a private organization, I mean, we do regulate private organizations. And this one operates more like a city. Like I said, it has bonding authority. It has all sorts of operates like that. But now I'm trying to remember what your second question is. I apologize.
It was just the definitions that were created in the bill. If there were, are they cross-referenced in any other part of the statute? Or are we creating these new definitions in the statute?
So I'm not sure which ones you're referring to, so I'd have to take a look at that.
Like donation, village, community, disbursement. It seems like it's new, but I didn't know if it was cross-referenced anywhere.
I don't know that. I can find out for you.
Further questions from the committee? All right, seeing none, thank you very much.
Thank you.
Thanks.
I appreciate it.
All right, have a good one. All right, with that, that'll conclude the hearing for House Bill 1356. We'll now move on to Senator Lewis Young. Yep, come on up. Senator Lewis Young.
Thank you, and good afternoon, Chair, Vice Chair, and members of JPR. I am here to present a bill that would actually repeal a current law. And I'm going to explain why the current law is actually defeating the purpose and why we already have a law in place that does that. Those are my two primary goals. So the bill is public health, prohibition on transfer of HIV, the repeal. The current law needs to be updated. And by the way, the current law is section 18601-1. That language was passed in 1989 at the height of the HIV panic. It hasn't been updated since. The current law criminalizes behavior that actually can't transmit HIV. After 30 years of HIV research and significant biomedical advancements to treat and prevent HIV transmission. Our current law is not only outdated, but it doesn't really reflect our current understanding of HIV. It's no longer a death sentence. People live long, healthy lives because not only is there prevention if you know your partner is HIV positive, but there is treatment today which didn't exist in 1989. The same standard is not applied to any other disease. For example, hepatitis is far more transmittable than HIV, and hepatitis C today is actually more dangerous. There's no evidence that draconian laws, such as what we have on the books today, actually reduce sexual risk behavior. And I hope to make the case that our current law is actually increasing the risk. Since 2014, at least 13 states have modernized or repealed their HIV criminal laws. I'm not going to read you all 13 states, but they're both red and blue states. So in Maryland, in the past 20 years, well, not actually past 20 years, I only have data from 2000 to 2020. There have been 104 cases reported. So 20 years, 104 cases, we're talking about roughly 5 cases a year. So this law isn't particularly effective at doing what it was originally intended to do. In fact, 80% of these charges were dropped at some point after the case was filed. When the cases were dropped, the defendant was frequently charged anyway, but charged with reckless endangerment, which reaffirms the point that Section 18601.1 is unnecessary, and also it's discriminatory. I hope to make that case as well. Our current law perpetuates stigmatization of people with HIV. The stigma created by the law actually disrupts our public health goal of ending the HIV epidemic by discouraging testing. Why does it discourage testing? Because the charge depends on whether someone knows their HIV status. So as long as this section remains law, it perpetuates the threat of criminalization for every person living with HIV who knows their status or suspects their status. The statute criminalizes the health status, not intentional wrongdoing. If HIV is virally suppressed and undetectable in a person, then it's not transmissible. This concept is called U equals U. Undetectable equals untransmittable. According to the CDC, of all people living with HIV in the US in 2016, 51% were taking common medications and were virally suppressed. This group, the group I just mentioned that were taking medications, accounted for 0% of new transmissions. 43% of transmissions that year were from 23% of individuals who knew their positive HIV status, but weren't receiving care. However, 38% of new transmissions in the same period came from the 15% of people living with HIV that didn't know their status. These statistics really illustrate that the small number of people who are living with HIV who don't know their status are responsible for a large portion of the new transmissions. In 2019, the United States announced a plan to end the HIV epidemic by 2030, with the goal of reducing new infections by 90%. However, the CDC has also stated that one of the biggest hurdles to testing treatment and the provision of resources is stigma, societal shame, misinformation, and a fear of legal reprisals prevent individuals from testing and discouraging status communication. Why do we want to encourage HIV testing and treatment? Well, I think it's kind of obvious if we remove the statutory provisions that reinforce stigma and create barriers to testing. We know care is critical for reducing transmissions. Public health strategies to end the HIV epidemic include people knowing their status, being in the care of medical professionals, and being on medical treatment. I also mentioned that there's real discrimination in terms of any kind of prosecutions. Black people comprise 82%, and this is state of Maryland, of all HIV-related prosecutions, but only 30% of the state's population, and 71% of people living with HIV in the state. Black men make up 14% of the state's population, and 44% of people living with HIV are Black men, yet they account for 68% of HIV-related arrests. Now, I also mentioned that we have a statute in place. Removing current law would not result in the inability of the state to prosecute actual and threatened transmissions with the intent to harm. The intentional, harmful transmission of infectious diseases, all infectious diseases, is already addressed elsewhere in criminal code, specifically under reckless endangerment. Now, I want to read you just a few passages. My cross-filer asked for an AG opinion in February on this specific issue. And here is the AG response. You asked for advice on whether an individual can be charged with reckless endangerment and assault in the second degree for the transfer of the attempted transfer of HIV. In my view, an individual who transfers or attempts to transfer HIV could be charged with reckless endangerment. One other sentence in this 4-page letter. An individual who knowingly engaged in activity that transmits HIV or could possibly transmit HIV, participated in contact that created a risk of death or serious physical injury, and arguably that individual consciously disregarded that risk. It is my view that those who have HIV and knowingly transmit or attempt to transmit the virus to others pose a risk to the lives of others and have a reckless disregard for their actions and the consequences of their actions, and therefore could be charged under the reckless endangerment statute. Moreover, I think that charging a person who, and this is my final quote from the AG letter of advice, I think that charging a person who acts with such a disregard for the harm that could stem from their actions would be in accordance with the legislative intent behind the reckless endangerment statute. So my point is, we have in statute something that would address this already. In addition to this AG letter of advice, the State's Attorney Association testified in favor of the bill, saying that it's time to remove 18601. And during the subcommittee debate, the State's Attorney Association confirmed that in their view, under reckless endangerment, they can prosecute other intentionally transmitted STIs also. So in conclusion, we've not responded yet to the new medical realities and the fact that we have some duplication in law, one that addresses it better. Nor have we addressed the unintended consequences of the existing law. The best way to combat HIV transmission is through testing, treatment, and destigmatization, not criminalization. Moreover, in terms of public opinion, polling shows that between 72 and 87% of voters support similar initiatives. You may recall that Governor Moore campaigned on this very issue in terms of repealing this law. The language of this bill in front of you promotes testing for HIV. By the way, in my testimony, behind my cover letter, I have included the full AG advisory letter. So in addition to promoting testing, which is the intent of this bill, and reducing stigmatization, it also will promote equity while allowing criminal sexual behavior to continue to be punishable under Maryland's criminal law, such as assault, rape, sex offense, reckless endangerment. You may see an amendment request before you. We believe that this amendment is not necessary. We believe that reckless endangerment already covers the intent of what's trying to be accomplished, and we don't want to single out any single disease because reckless endangerment covers, we believe, all STIs as well as the AG's office. So with that, I will conclude and entertain any questions.
I had a question for you. Are we listening to anyone else, or is it just? Ms. King, since she's here, the state's attorney.
She's here for questions because I'm not a lawyer.
Right. Yes. Right. The question that I have, and I have heard loud and clear from the sponsor that the bill is not necessary. MHA is saying they're favorable with amendment, which is to say infectious or contagious disease, and to replace that with HIV. The question is, what statute is the bill's sponsor referring to with reckless endangerment, and how often has the reckless endangerment statute been used to deal with folk who have had other infectious diseases and essentially weaponize them to victimize someone?
Joyce King on behalf of the Maryland States Attorneys Association. I co-chair the SVU subcommittee, and we workshop this bill as well as sought out case examples with regards to HIV and other STIs. And the consensus was that it was regularly being used. It was actually the preferred statute to proceed on with regards to the intentional infliction of STIs.
So it is used.
It is currently being used.
Thank you.
You might also recall early in my testimony, I mentioned the number of cases in 20 years, and 80% of them actually were covered by reckless endangerment instead of the statute in place today.
Thank you, Mr. Chair. Two questions. First of all, is there any section of the code that covers any other intentional transmission of a disease, such as, say, COVID or something like that? Or is this the only part of the code that criminalizes the intentional transfer of a disease?
There is, under the public health code, there are different subsections with regards to the transmission of other illnesses.
What
respiratory, they're minimal criminal. We don't utilize them in the criminal space, but I think that I know that there were attempts with regards to COVID. I can send you the specific statutes.
Yeah, I'd like to see whether this is, whether we do this with some frequency in the code to try to, I couldn't imagine intentionally trying to infect someone with the disease. And if I were to do that, I would hope I would be prosecuted. So if there are other sections of the code which speak to other specific diseases, I guess my question is, why are we going to repeal this one and leave the other ones intact? My second question is, what is the penalty for reckless endangerment? In this case, the penalty is for a fine up to $2,500 or imprisonment up to 3 years. What for reckless endangerment, what is the penalty?
It's the same.
The same?
3 years, yes.
Oh, okay, fine, thanks.
Actually, I thought reckless endangerment.
5, sorry, I'm 5 years.
It's 5 years, and it's a larger fine also. The fine is $5,000 as opposed to $2,500. So the penalty for reckless endangerment's much greater. Sorry, but I
No.
I spent the whole weekend reading this stuff.
But could you refer us to the other sections?
Yeah, I'll send
of
that to the
code that
committee.
Cover other diseases?
It's not the intentional infliction. There are other parameters with regards to public space and bringing an infectious disease into a public space, but I can send it.
Okay.
It's distinguishable from this statute.
Okay, that would be helpful. Thanks.
So MHA and MCASA had amendments that were kind of geared toward the same goal, but I'd like to get your opinion on their amendments, because MHA's amendments were very kind of clean. It's just one word change, I think. And then, but MCASA had, I thought, some pretty intriguing amendments. I wonder what your thoughts were on those. Yeah.
The Maryland States Attorneys Association. The Maryland States Attorneys Association, I think, reviewed the initial version from MCASA, which was communicable disease, and there was reluctance because that was a very broad term. I believe that the new amendment, and I think Mr. Jordan's here, with regards to non-respiratory communicable diseases, there was openness to that amendment. However, the creation of a new crime and a new statute, we were also felt that could be a separate bill.
All right, seeing no further questions. Thank you very much, Senator.
Oh, I do want to add one more thing, that the House has passed this bill in a bipartisan manner 2 years in a row. Thanks very much.
Thanks. I don't know if that helps or hurts the bill in JPR, but I have to say it. I'm sorry. All right. Seeing no further questions, that will conclude the hearing for Senate Bill 1165 and the hearings for the day. We're going to gavel out, restart, take a quick break, and then we have a voting session. So let's come back in 10 minutes.